Welcome to this explainer. Today, we're not just looking at some dry list of rules. We're laying out an absolute battle plan. What we're about to explore is literally the mapping of a centuries-old legal revolution. We're going to look at how Indian law relating to women transformed from an ancient blueprint of total equality, descended into a brutal battlefield of oppression, and finally fought its way back to constitutional triumph. Let's get right into it.
Okay, let's dive into this. Here is our roadmap for today. We've got 5 main stops. 1. History and the constitutional framework. 2. Marriage, divorce, and separation. 3. Muslim law and maintenance. 4. The criminal justice shield. And finally, 5. Dowry and reproductive autonomy.
Section 1. History and the constitutional framework.
History isn't just a straight line, right? It's more like a pendulum. Back in 1500 BC, during the Vedic period, we hit a serious high point. Women were scholars, philosophers. Think of figures like Gargi and Maitreyi. They had absolute equality. But then, fast forward to 500 BC, the Smriti period. The pendulum swings to a brutal low. Texts like the Manu Smriti actually declared that a woman never deserves independence. And that triggered centuries of child marriage, vanishing property rights, and forced seclusion. It literally took until 1829, during the British era, pushed by Indian reformers like Raja Ram Mohan Roy, to secure the very first modern legal protection, the abolition of sati. But the true, triumphant arrival of equality, that happened in 1950. The Indian Constitution was the absolute game changer.
So let's look at the Constitution itself. This is our master blueprint. We've got Article 14, guaranteeing equality before the law, and Article 15.1, strictly prohibiting sex discrimination. But pay close attention to Article 15.3. We call this the golden exception. It explicitly allows the state to make special provisions specifically for women. This single clause is literally the constitutional license for every single protective law we're discussing today. Add in Article 16 for equal public employment, and then there's Article 21, the right to life with dignity. Article 21 has become the most expansive, powerful tool for women's rights in India.
Let's see these articles actually in action, using the FRAC method, breaking down the facts, the issue, the rule, and the conclusion. In the landmark Vishaka case, a social worker was gang raped, and believe it or not, India had absolutely no law against workplace sexual harassment. So what happened? The Supreme Court stepped right in using Article 21's right to dignity and forged the binding Vishaka guidelines themselves. Then, in Air India versus Nargish Mirza, air hostesses were being forced to retire the moment they got pregnant. The court completely smashed this rule using Article 14. They concluded that penalizing a woman for a biological function unique to women, that is pure, unconstitutional sex discrimination.
Section 2. Marriage, divorce, and separation. Now, before 1955, Hindu marriage was this indissoluble sacrament, no way out. The Hindu Marriage Act, the HMA, completely changed the game by setting uniform rules and actually allowing for divorce. For a valid Hindu marriage, just remember this easy mnemonic: one mind-age relation, one spouse only, sound mind, legal age, and outside prohibited relations. And from a strict legal standpoint, the ceremony becomes completely binding the exact moment the 7th step of the Saptapadi is taken around the sacred fire.
Now, what's really fascinating here is the aggressive difference between Section 11 and Section 12. A void marriage under Section 11 is a legal zero. It never legally existed. This applies to major absolute violations like bigamy or marrying within prohibited degrees. But a voidable marriage under Section 12, say one involving force, fraud, or a total lack of consent, that actually exists. It is fully valid right up until the wronged party aggressively petitions a court to annul it. The power to destroy that marriage rests entirely in the hands of the petitioner. 2 monumental cases really define the modern boundaries of Hindu divorce. In Naveen Kohli, the Supreme Court definitively expanded the definition of cruelty. It's not just physical violence anymore. Sustained mental abuse and systematic emotional harassment are absolutely enough to dissolve a marriage. Then we've got Sarla Mudgal. Hindu men were converting to Islam solely to exploit multiple marriage allowances. The court firmly slammed this loophole shut. They ruled that conversion does not magically dissolve your first marriage, and any subsequent marriage is void. It constitutes the exact crime of bigamy.
Section 3. Muslim law and maintenance.
Because a Muslim marriage, or nikah, is a civil contract with an offer, acceptance, and mandatory consideration called mahar, it can be dissolved in a few different ways. We've got Talaq-ul Hasan, which is the most approved, and it's reversible. There's Talaq-ul Hasan, which happens over 3 successive periods. Khula, which is initiated by the wife, and Fasq, which is a court-ordered dissolution. But hit the brakes right here on Talaq-ul Bidat, instant triple talaq.
This allowed a husband to irrevocably destroy a marriage in literally seconds. Today, this form is entirely unconstitutional, void, and a straight-up criminal offense in India.
So, the really crucial point here is understanding how these three specific landmark cases form one continuous narrative arc of protection for divorced Muslim women. First up, Shah Bano in 1985. This established that Section 125 of the Criminal Procedure Code, the CRPC, is a secular law, meaning Muslim husbands must prevent a divorced wife's destitution even beyond the iddat period. When lawmakers tried to limit this protection in 1986, the Daniel Latifi case in 2001 brilliantly stepped in. The court harmoniously interpreted the new law to actually mandate adequate lifelong provision. And finally, Shah Bano in 2017 struck the ultimate blow for equality by declaring instant triple talaq manifestly arbitrary and completely unconstitutional.
And right before we leave the private sphere, consider this truly powerful precedent from S. Kashabu versus Kenyamal. An actress simply expressed her opinion that premarital sex and live-in relationships were a matter of personal choice. The response? She was hit with over 20 criminal complaints. But the Supreme Court stepped in and quashed every single one of them. They declared unequivocally that live-in relationships between consenting adults are perfectly legal in India, firmly securing the right to personal choice and free expression.
Section 4. The Criminal Justice Shield.
Let's reverse engineer why these specific evidence laws exist. Think about it. If a woman is killed or driven to suicide in the total privacy of her matrimonial home, there are no independent witnesses. The victim is dead, so who testifies? Parliament solved this by brilliantly shifting the burden of proof. Under Section 13A, if a woman commits suicide within 7 years of marriage and there's cruelty involved, the court may presume the cruelty caused it. But under Section 13B for dowry death, if an unnatural death and dowry cruelty are proven, the court shall presume guilt. It is absolute, mandatory. The burden of proof completely flips onto the accused to prove their innocence.
Look at how the Indian Penal Code splits this up. Section 304B punishes the fatal result, the actual dowry death itself. Section 498A punishes the cause, the cruelty, and the harassment. Now, in the Hira Lal case, the defense actually tried to argue that the dowry harassment didn't happen on the exact day of the death. Nice try, but the Supreme Court permanently closed that loophole. They ruled that soon before death simply means approximate time, part of an ongoing pattern. It absolutely does not mean immediately before.
The evolution of India's criminal code is literally written in the aftermath of horrific failures. Back in 1979, the shocking acquittal of police officers in the Mathura custodial rape case ignited a massive national movement. That forced the creation of laws presuming a lack of consent in custodial rape. Then in 1991, the Madhukar case finally laid down the law that a victim's past sexual character is totally irrelevant in a rape trial. In 2014, Lakshmi's public interest litigation forced the strict regulation of acid sales and mandated survivor compensation. And in 2018, the Joseph Shine case decriminalized adultery, declaring once and for all that a woman is an autonomous individual with moral agency, absolutely not the property of her husband.
Section 5. Dowry and Reproductive Autonomy.
Let's clear up one of the absolutely most critical economic distinctions in Indian law. On the left side here, dowry. It is an illegal, highly penalized crime where property is demanded in connection with the marriage and handed straight to the groom's family. On the right, Sridan. This is perfectly legal. It represents gifts given voluntarily to the bride. And here's the kicker. Sridan is the wife's absolute, exclusive property. If the husband or the in-laws try to unlawfully retain it, they are straight up guilty of criminal breach of trust.
Finally, let's examine bodily autonomy through the Medical Termination of Pregnancy Act. Just think of this as 3 doors of increasing restriction. Door 1, up to 20 weeks. Access is broad and just requires one doctor's opinion. Door 2, 20 to 24 weeks. This is for specific vulnerable categories like assault survivors, and it requires 2 doctors. Door 3, beyond 24 weeks, strictly for severe abnormalities requiring a full medical board. But listen, here is the absolute most empowering legal takeaway for you. The consent of the woman herself is the only consent required. Her husband's consent, it is legally irrelevant. This autonomy was powerfully cemented in 2022 with the X versus Principal Secretary ruling. The Supreme Court decisively declared that excluding unmarried women from that 20 to 24-week abortion window was blatantly unconstitutional. They expanded the law, proving that reproductive freedom and bodily autonomy under Article 21 apply to all women equally, regardless of their marital status.
So, we have just mapped out a monumental legal revolution. We charted the course from the depths of the Smriti period all the way to the triumphant heights of the modern Constitution. The Supreme Court has systematically dismantled patriarchal controls across marriage, criminal justice, and bodily autonomy. The blueprint for equality has been drafted and it's been fiercely defended in the courts. But the ultimate question remains, does society's mindset finally match the law's blueprint, or is the battlefield simply shifting from the courtroom straight into the living room? Thank you for joining this explainer.